Hi guys, welcome back to my channel. So today in this video I would like to read an article entitled Atlantic Confidence Breaking the 1976 Limitation for Maritime. In a landmark judgment, cargo interests have defended an application made by the owner of a bulk carrier to constitute a limitation fund. In what is being described as a landmark judgment, Carriers Shipping v. N.K. & Co. LLC, the Atlantic Confidence Admiralty, before Mr. Justice Tier, cargo interests have successfully defended an application made by the owner, the bulk carrier MV Atlantic Confidence, of the vessel to constitute a limitation fund pursuant to the Conventions on Limitation of Liability for Maritime Claim 1976. The owner's application to limitation was brought following a fire and subsequent sinking of the vessel in depth water off Oman in 2013. Cargo interest has their suspicions about the cause of the loss of the vessel and sought to argue that the fire and subsequent sinking of the vessel were as a result of a personal act or omission by the owners. Article 4 of the Convention headed Conduct Bearing Limitation states, a person liable shall not be entitled to limit his liability if it is proved that the loss resulted from his personal act or omission committed with the intent to cause such loss or recklessly and with the knowledge that such loss would probably result. Fact: the vessel was on a laden voyage from Ukraine to Oman with a cargo of steel products destined to be used for the building of a new passenger terminal at the Muscat International Airport. Around daybreak on the 30th March 2013, fire reportedly broke out near a generator and storeroom on the starboard side of the vessel engine room. The crew abandoned ship, although curiously both the master and chief engineer returned to the vessel twice. On one occasion, the master returned with a bag of tools, including spanners, a wrench, and a hammer. The vessel sank on 3rd April and the crew were rescued. Burden and standard of proof. The burden of proving such a personal act or omission falls upon the cargo interest and is judged on the balance of probabilities. It was recognized by Mr. Justice that the approach should be the same as it is when a shipowner makes a claim on a hull insurance policy and the insurer alleged the ship was scuttled. However, whilst the burden of proof is on the balance of probabilities, it should be recognized that the standard of proof is very high. In particular, Mr. Justice Tier agreed with the approach taken by Mr. Justice Aikens in the case Brownsville Holdings Limited v. Adam J. Insurance.co. The Milasan 2002 Lyot Report 458, where at paragraph 28 it was stated, however, as such allegations amount to the accusations of fraudulent and criminal conduct on the part of the owner, then the standard of proof that the insurer must attain to satisfy the court that its allegations are proved must be commensurate with the seriousness of the charge laid. Effectively, the standard will fall into far short of the rigorous criminal standard. Consequently, such cases are notoriously difficult to succeed. In this case, the physical evidence lay on the ocean floor in deep water. Consequently, it was necessary for the court to piece together the event before, during, and after the casualty, as well as assess the plausibility of the explanation provided by each side expert as to the cause of the loss of the vessel. The evidence. Various witnesses of fact gave evidence, including the owner, master, chief engineer, superintendents, and some junior officers of the vessel. In assessing the quality of this evidence, in most of the cases, particularly with the more senior personnel, Mr. Justice Thier treated their evidence with caution. Various experts also assisted the court in providing alternative explanation for the loss. In part, these explanations were based upon the witness evidence photograph of the abandoned vessel before the sank, as well as other evidence such as from a recent previous dry docking. Each party's expert provided an opinion as to both the cause of the fire and the sinking. The owner case was the fire state when a fuel line fractured on the number 2 generator. The fuel then sprayed towards the number 1 generator, which resulted in a pool of fuel accumulating in the generator's safe hole. The spray then changed direction into the hot surface of the unlatched turbocharger on the number 2 generator. This ignited and the turn ignited the fuel in the safe hole. The fire then spread to a storeroom. The spray then changed direction again toward the storeroom. Cargo interests sought to allege that the fire was deliberately started. Having considered all the evidence, Mr. Justice Thier concluded that each sequence of events described above was unlikely, and further still the aggregations of such unlikelihoods led him to conclude that it was more likely than not that the fire stayed in the storeroom and not as stated by the owners. Further, given that no explanation had been put forward by the owners as to how the fire could have started accidentally in the storeroom area, there was a real and substantial possibility that the fire in the storeroom was started deliberately. The sinking. Owner's case again relied upon a sequence of events occurring. In particular, the head of the fire caused a crack in the hull below the waterline in way of the storeroom, whilst at the same time the fire caused damage to electrical cabling controlling valves in the ballast tanks. The damage to the lighting was declined as hot wiring. But in essence was a short circuit of parts of that system that allows certain valves to open. Whilst Mr. Justice Thier accepted that a crack in the hull was a theoretical possibility, he preferred the evidence provided by one of cargo interests expert that if there had been a crack, that there would have been evidence of distortion and booking in the sail plating deck. The photographs taken of the vessel after her abandonment but before the sink showed no such distortion or buckling. As to hot wiring, the evidence was that for this to happen, 5 events had to occur. The Admiral Justice Thier again concluded that whilst it was possible that all 5 events occur, that possibility was remote. Cargo interests sought to allege that the vessel was deliberately scuttled by deliberate opening of sea chest and ballast tank valves. Other evidence: certain events happened before, during, and after the loss, which could be properly or credibly explained by the witnesses. Cargo interests argue that this further pointed to a deliberate action to cause the loss. The events include a change of course to deeper water in the few days before the fire. The fact that another vessel under the same management had called to Muscat before reversing with the casualty, but owner had not told sailors who happened to be mobilizing in the same port at the same time of the distressed vessel. So that's all the article. Bye bye and see you on my other video. Bye.